Hello, everyone. Welcome, and thank you for attending today's webinar. It's called the DOJ Cyber Fraud Initiative, Cyber Faces the FCA Hammer. Before we begin, we have a few housekeeping items to go through. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try and answer these at the end of the webcast, but if we need to provide a fuller answer or if we run out of time, which is quite possible, we'll answer it later by email. A copy of today's slide deck is available in the resource widget on the screen, and you can find additional answers to some common technical issues in the help widget that's also at the bottom of the screen. The webinar today is CLE accredited in California, Illinois, and Texas for 1 hour of general credit, in Missouri for 1.2 hours of general credit, in New York for 1 hour of skills credit for experienced and transitional attorneys. We award CLE based on attendance for the entire 60 minutes. We'll display and announce secret words in 2 polling questions that will come up during the webinar. You'll be required to select from the list what the appropriate secret word is and enter that in, and then you'll in order to receive your credit. Please respond to them to demonstrate your continued engagement and earn your full CLE credit. We value your opinions and appreciate your participation in the course today. Today we have a great panel to discuss a new, interesting occurrence in the cyberspace, a new initiative by the U.S. Department of Justice to improve cybersecurity compliance. The initiative has the capability to result in significant liability for companies. It also creates the possibility of liability from whistleblowers reports or from whistleblower actions. This is somewhat new in the field of cyber, although it's been common in other areas like healthcare in the past. And so we have a phenomenal panel here to talk about this today. I am Jim Shreve. I chair the cybersecurity practice here at Thomson Coburn. I've been doing cyber security for nearly 25 years now, and I've advised clients in a variety of different spaces, including higher education, financial services, government contractors, several areas. One of my co-panelists today, Claire Schenk. Introduce yourself, Claire.
Good afternoon. Thank you, Jim. My name, again, is Claire Schenk. I'm a partner with Thomson Coburn. I serve as a member of our white-collar defense and investigations practice group, which includes the defense of Civil False Claims Act cases. I learned about the Civil False Claims Act many years ago when I worked as a civil prosecutor with the Department of Justice, and enjoy this practice area. Christine?
Hi, everyone. My name is Christine Couvillon. I'm in Washington, D.C., and I specialize in helping companies who do business with the government contractors, higher education, and other organizations, and work a lot with Claire on Civil False Claims Act investigations and cybersecurity for those heavily regulated industries that I just talked about. Thank you.
Hi, good afternoon. My name is Casale, and I'm an associate at Thomson Coburn in the St. Louis office. And I have experience in cybersecurity and working on various privacy issues. And I also have experience with various litigation and business litigation issues. And now I'll turn it back to Jim.
All right, thanks very much, everybody. So this slide kind of shows you what we're going to go through. I mean, so Claire is going to talk some about what is the Department of Justice Cyber Fraud Initiative, and then she's going to look at what this underlying law that the False Claims Act. What does that mean? What is entailed there? Christine's going to talk somewhat about how this impacts government contractors. Who's subject to this, and what how it may impact them. We'll look at some of the False Claims Act settlements, some state. Libby will look into some state False Claims Act laws, and then we're going to discuss a few ways that you might be able to mitigate your risks of getting this kind of action and complying with the underlying cybersecurity requirements that this is designed to address. So, and then we'll close and take some questions at the end. So with that, I'll pass it to Claire. Let's kick it off.
Thanks so much, Jim. DOJ Cyber Fraud Initiative. What is the DOJ's Civil Cyber Fraud Initiative, and how does it relate to the False Claims Act? This initiative was announced in October 2021 and prioritizes enforcement of the Civil False Claims Act, 31 U.S.C. 3729 et sec. We'll refer today to the statute as the FCA, against companies that knowingly violate cybersecurity requirements in government contracts and grants. Jim, next slide, please. What is the scope of the DOJ cyber review? The FCA initiative is only one piece of an ongoing DOJ cyber review and does not eliminate the exposure government contractors and grant recipients may face on other fronts. Other sources of liability include enforcement actions by the SEC for violations of the Safeguards Rule, Section 5 violations of the FTC Act, actions for violations of HIPAA, class actions by individuals and actions brought by state attorneys general, administrative sanctions such as debarment and criminal liability. But today our focus will be on the FCA and the type of exposure faced by grantees and government contractors. Jim, next slide, please. So why is DOJ focused on ramping up enforcement efforts under the FCA? Because DOJ has been wildly successful in obtaining massive recoveries with the FCA and also obtained a degree of success in deterring fraudulent conduct resulting in the loss of federal program funds. With recoveries under the FCA, DOJ returns funds to the victim agencies and also helps to deter fraudulent conduct due to the heavy threat of large damage amounts and substantial penalties. While we do not have the numbers in yet for 2022, DOJ reported last February that its settlements and judgments exceeded $5.6 billion in fiscal year 2021. This sum is the second largest amount recorded and the largest since 2014. The bulk of the recoveries, over $5 billion, were obtained in healthcare fraud matters. Again, the recoveries by the DOJ include not only restitution to various government agencies for sums lost due to fraud, but also a multiplier of losses and penalties for each false claim submitted. The multiplier is up to 3 times the amount of the loss, and the penalties are, depending on the time period with an adjustment for inflation, between $11,665 and $23,331 for each false claim submitted and or false statements submitted in support of a claim. With the deterrent effect of these damages and penalties through the cyber initiative, the DOJ intends to build resiliency against cybersecurity intrusion, hold contractors and grantees to their commitments, ensure that companies that follow the rules are not at a competitive disadvantage, and improve cybersecurity practices. Jim, next slide. So why did DOJ make this announcement, and what does it mean? Suits in FCA cases are often initiated by key time relators, otherwise known as whistleblowers. In fact, the bulk of the funds recovered by the DOJ are in cases initiated by whistleblowers. Key time whistleblowers are often disgruntled former employees, but they may also be industry competitors or others with knowledge of wrongdoing. Whistleblowers stand to gain between 15 to 30% of the sums recovered by the DOJ. This provides a powerful incentive for otherwise reluctant informants to come forward. DOJ continually encourages those with knowledge of wrongdoing to come forward, telling prospective relators, if you see something, say something. We will see that you are protected from retaliation and compensated. And in fact, the FCA does contain a provision for independent proceedings involving retaliation. Also, there's a growing awareness of the threats that we all face from cybercrime, and DOJ, government actors, and politicians want the public to be aware that they are trying to do something about this growing problem. As a result, resources will be directed to this area. There will be training, additional funding, potentially dedicated lines of funding, special units, dedicated AUSAs, and the sharing of information and resources between offices. While today we're talking about 2 recent FCA settlements, we may see an exponential growth of these cases over time. Both civil AUSAs and relators learn from each other, and this will certainly result in an increased number of cases. While healthcare FCA cases now eclipse defense cases, perhaps over time, cyber cases will overtake healthcare and other types of FCA cases. Jim, next slide, please. So, what is the DOJ focused on in these cases and in this initiative? In its announcement, the DOJ outlined 3 types of allegations that it may pursue. First, knowingly providing deficient cybersecurity products or services. 2, knowingly misrepresenting their cybersecurity practices or protocols. Or 3, knowingly violating obligations to monitor and report cybersecurity incidents and breaches. So each of these allegations, as you may have gathered by now, are typically going to pertain to government contractors and grantees. So also, as you can see, these civil FCA prosecutions are not really focused on those that we may normally see as the primary bad actors who may be subject to criminal prosecution. For example, those hacking into government systems and stealing funds. Rather, this recent DOJ cyber initiative is taking a very close look at the activities of those entrusted with the responsibility to provide related cybersecurity systems to the government. Jim, next slide, please. So what does knowingly mean? You know, we've been describing that knowing activity is required in order for there to be a viable prosecution under the civil FCA. So it's really important here to understand that knowing under the FCA is defined as whether the prospective defendant knew, meaning actual knowledge, acted with deliberate ignorance of truth or falsity of the information, or acted with reckless disregard of the truth or falsity of the information. As described in the FCA legislative history, the FCA definition of knowledge is designed to avoid ostrich-like behavior by those who should have been aware of false information and simply stuck their heads in the sand. So also, defense attorneys handling these cases must know that the requisite knowledge of a civil FCA defendant does not include an innocent mistake, mere error, or negligence. The standard for an FCA case must at least rise to the level of reckless disregard or deliberate ignorance. Jim, next slide. So finally, how does a prosecution of a civil FCA case differ from a criminal violation? For example, I recently handled a criminal case prosecuted under the Computer Fraud and Abuse Act. This statute outlaws conduct that victimizes computer systems and protects federal computers, bank computers, and computers connected to the internet. So it shields them from trespassing, threats, damage, espionage, and from being corruptly used as instruments of fraud. And the charging statute, 18 U.S.C. 1030 A5A, pertains to knowing and intentional activity, the transmission of a program, information, code, or command to a computer or computer system. So as I stated a little earlier, the FCA version of knowledge simply does not require actual intent or even actual knowledge. So what this means is that prosecutions under the civil FCA simply require a lower threshold of knowledge. This means that some cases which might be declined for criminal prosecution will be viable sources for a civil FCA case if there are program losses. So Christine, I'm going to pass this over to you.
Thank you. I'll interject there for just a moment. It's time for our first secret word. And so today's secret word is cyber. So please select cyber from the words on the screen. And then we'll give everybody a few moments to do that, and then we'll move on to Christine. So please go ahead and select cyber from the list of choice of responses on the screen. We'll give just a few more seconds, and then we're going to move on. So, okay, 5. Okay, here we go. Christine.
All right. Hey, everyone. I want to spend a few minutes talking about who this impacts the most and how those companies get on the hook for FCA liability under the cybersecurity regulations. So a primary source of potential liability for the FCA for cybersecurity violations are government contractors. And grantees. Claire had been talking about that. Many grantees are subject to these regulations, even though they may not focus on them. So let's talk about the specific clauses you want to look for. So for companies doing business for the government, with the government, receive grant funding, or that work for prime contractors that may do business for the government, you may already be familiar with these clauses. If you are in a company that does business with the government and you're not, that's definitely something you want to check your contracts for. So these clauses are the main clauses right now that apply to companies doing business with the government or receiving grant funds from the government. And so the way that Claire was talking about companies getting on the hook for False Claims Act liability is through making false representations. And the representation in this instance could be made in your contract, in your company's contract, or if your company is certified under CMMC, which is a whole separate program unto itself, then you will make certain certifications and representations when requesting payment for the government. And one of those would be compliance with these clauses. So, and that would be in the process for certifying for CMMC or in your contract. So these clauses, so the first one, FAR 52-204-21 is basic safeguarding of covered contractor information systems. And I think that's a very appropriate way to describe it because it contains about 26 subpoints on which contractors have to represent that they comply. If this clause is in your contract or your grant, it's likely because your company is handling some government data. Your company does not have to be an IT contractor for the government in order to have these clauses in their contract. That's a very important point because while IT contractors probably will, also many other kinds of contractors and grantees will have these contracts clauses in their contracts and grants. This clause specifically shows up in almost all government contracts and subcontracts. It's all over the place because the government is really interested in improving the cyber hygiene, improving the cybersecurity defenses of anybody that holds any government data or gets government data transmitted through their systems. But like I said, basic safeguarding is really a floor. And if you go through this regulation, you'll see a lot of sort of common sense security tactics that we're probably already pretty used to from having worked in offices or having worked in this new post-pandemic reality of working from home. It's things like limiting access to the physical space, limiting access to computer networks, things like two-factor authentication or password safety requirements, or routine making sure the company does routine computer updates. All of these things are things that most companies should already be doing, and won't necessarily protect you from being hacked, but will, at least if your company is meeting all of these requirements, will at least protect you from having made a false representation under this clause under your contract. So these next two, this clause is also, it's a DFARS clause, which means it applies to anybody holding a contract with the Department of Defense or holding a grant from the Department of Defense. The DFARS applies solely to DoD contractors. And it's more specific, and this clause is more about safeguarding the government's data itself, as opposed to the system and the system requirements from the last clause. This isn't about classified systems either. I think, a lot of us can imagine that classified systems have a whole lot of security requirements, which they do, but this clause is specifically applying to unclassified contractor systems. Any system that processes, stores, or transmits DoD contract information or technical information. It's almost any information that is related to a DoD contract. And so this clause, if it's in your contract, requires protections under NIST 800-171, which is a whole schema of protections that the government has come up with to outline cybersecurity practices, best practices, including the ones we just talked about and the FAR clause, about those 26, but there are a lot more included in NIST 800-171 than in that initial clause we just talked about. One of the biggest and most important things in this clause that is requiring incident reporting to be rapid. If you have a cyber incident, and that can mean almost anything, any kind of intrusion, hack, ransomware, malware, maybe not all malware, but most instances where it appears that your computer system has been compromised, then this clause requires you to rapidly report that incident, and that the company also has to maintain that data, anything related to that incident, for at least 90 days. And this place in the regulation seems to me a place where a contractor could get caught up if nothing in the regulation defines rapid reporting. But in cybersecurity world, rapid reporting is always very fast. Many of the privacy laws require 24 or 48-hour reporting, and so I think if I were advising a client who had been hacked, I would say rapid reporting means pretty much as soon as you know there's been a problem, and that can be a lot to coordinate for companies and a lot to coordinate with the contracting officer. But if a company doesn't report that rapidly, this could be a very big hook for FCA liability if a company has certified that it's complying with this clause and hasn't reported a malware incident, for instance, after, I don't know, a few weeks, and they've dealt with the malware incident and then they didn't report it. That could be exactly what DOJ is looking for, those sorts of incidents. That's just one example. The other clause, I'm going to go back a minute because there was a slide that didn't get in. This third clause on this list, DFARS 252, 204, 7021, is about CMMC. And CMMC, in the cyber world, in the cybersecurity government contracts world anyway, has become the thing to keep an eye on. And as I said, it can be its own CLE program, but at a high level, it's about, it's a tiered classification system created by the DoD to certify various contractor practices. So if you're at a certain tier, if you're at tier 3, for instance, in CMMC 2.0, it means that some outside organization has audited your security practices and your systems and found that you meet this very long list of government requirements, which includes the NIST 800-171 and NIST 800-172, which is a separate set of requirements. Level 3, CMMC 1.0 came out a few years ago, and then it was recently updated. There's a proposed rule out now that was updated to CMMC 2.0, and the government is still working on some details in that. It hasn't been fully released as a final rule, but they're trying to streamline from CMMC 1.0 and trying to implement the third-party accrediting organizations who can certify companies for compliance with CMMC 2.0. Essentially, the level that you're certified with under CMMC tells the company which contracts it can bid for. So the expectation is in the near future that some contracts will be only available to bidders who have been certified at specific CMMC levels. That remains to be seen exactly how that'll work because the rule hasn't been finalized, but that is the expectation. And again, with the False Claims Act, it would be the hook for liability would be where an organization has, for instance, maybe made certain representations during its CMMC audit or classification, and those representations either become outdated because something fails or something changes, or they were false in the first instance. And in those sorts of representations would be an instance where liability could be found under the FCA, especially if there's a breach or some damage to the government. And I think I'm going to turn it over to Libby. Oh, excuse me, to Claire.
Thanks, Christine. And what have we seen in the wake of the DOJ's announcement regarding reliance upon the civil FCA to combat cyber fraud? So we've seen 2 FCA settlements since the announcement of the cyber initiative. These cases provide some insight into the type of scenarios that may give rise to exposure under the FCA cyber initiative. I have the 2 sites up there for you, and the first of the 2 cases, which has involved an FCA settlement, is United States of America versus Comprehensive Health Services, and we'll refer to that entity today as CHS. So this settlement actually arose from 2 separate civil actions filed under the Keaton provisions of the FCA against CHS. Not an unusual occurrence, by the way, to have multiple filings over the same matter. Lots of whistleblowers out there. CHS was a party to contracts and subcontracts with the Department of State to provide services to government facilities in Iraq and Afghanistan. As the basis for the settlement, the U.S. alleged that CHS was required to provide a secure electronic medical record to store confidential medical records, including the identification of U.S. service members, diplomats, officials, and contractors working and receiving medical care in Iraq. CHS knowingly, under the standard of the FCA, submitted claims for reimbursement under the contract that failed to disclose that CHS had not complied with the terms of the contract, which required CHS to store patients' medical records on a secure electronic medical record, and the Department of State paid CHS under the contract, meaning that there was a loss to a federal program fund. So specifically, CHS had not stored patient medical records of U.S. service members, diplomats, officials, and contractors working and receiving care at the facilities. It left scanned copies of records on an internal network drive that was left accessible to staff without a need for access, and failed to take adequate steps to remedy these concerns when raised by staff members, which obviously contributes to the level of knowledge that we've been discussing today. So as a result of these actions, the United States alleged that CHS falsely represented to the government that it complied with terms of its contract that required maintenance of a secure electronic system for medical records by submitting claims for reimbursement under the contract without disclosing that it had not complied with the contract term requiring medical records to be stored on a secure electronic medical record. Also, failed to consistently comply with contractual requirements regarding the storage of medical records, but nevertheless submitted claims for reimbursement for cost of storing such records. And finally, receiving payment for claims related to construction of and storage of medical records on an electronic medical record, and failing to disclose that medical records were also stored on an internal network drive that non-clinical staff could access in violation of the contract. So as part of the settlement with the government last spring, CHS did not admit to any wrongdoing, and it agreed to pay the government $930,000 along with $531,691 for attorney's fees for the whistleblowers who brought the key time leading to the settlement. Of the settlement, the 4 relators will receive a total of $172,050. The reimbursement received by CHS, which gave rise to the key time claims, and ultimate settlement totaled $474,018. So you can see that the cost of the settlement far exceeded the original benefit to CHS. So the second of the 2 settlements we'll discuss today, also the site is on the screen that you see in front of you, is United States XREL Marcus versus Aerojet Rocketdyne Holdings. And the parties reached this agreement last June. Here, Aerojet was a contractor to the Air Force, Army, and Missile Defense Agency. A relator brought suit against Aerojet, alleging that Aerojet failed to safeguard unclassified technical information from cybersecurity threats as required by its contracts with the government. Additionally, the suit alleged that Aerojet fraudulently entered contracts with government agencies by misrepresenting the extent to which they complied with the cybersecurity requirements of the agencies while knowing that they did not meet those requirements. The case was filed in 2015, and we haven't discussed it previously, but would have been filed under seal as required by the FCA. And on June 5th, 2018, the DOJ notified the court that it was not intervening and that it declined to take over the action under 31 U.S.C. 3730b4. This is contrary to the DOJ action in the other case that we just mentioned, in which case DOJ actually did intervene in the suit. So under this provision of the FCA, where DOJ declines to intervene, the relators have the right to conduct the action, although the United States remains as the real party in interest. In this case, the United States recovers the proceeds, nevertheless, even though it didn't intervene, but that sum is less the sum paid to the relators and counsel. And in this type of case, the relators would recover a larger sum because the United States did not intervene. So the United States reviews the settlement and here ultimately did sign off on the settlement, which was submitted to the court for approval. So even though the United States did not intervene in the case, they certainly had input and took a close look at the allegations in the settlement. So there were numerous motions throughout the case, which progressed for a number of years, and it was settled shortly before it was supposed to go to trial in April of 2022. So there had previously been a denial of a motion to dismiss the claims, alleging that misrepresentation in obtaining the contracts by Aerojet. The court also permitted the relator to proceed with a theory of promissory fraud in addition to the FCA claims, which allows liability for each claim submitted under a government contract obtained by fraud. So further, in February 2022, in denying the defendant's motion for summary judgment, the judge held that there existed issues of fact as to whether Aerojet's misrepresentation of its compliance was material to the government's decision in proving contracts. So likely as a result of these events, the parties reached a settlement of $9 million in April 2022, shortly before trial, due to the potential exposure for losses should Aerojet be found civilly liable. So that's my overview of these large, important, and complicated cases. And I'm going to turn it over to Libby now for her remarks.
Thanks, Claire. So many states also have False Claims Act-like statutes. So they're not all identical to the Civil False Claims Act, and while they have and serve similar purposes, they don't all cover the same types of fraud. So examples of some states that do have False Claims Act laws include California, Illinois, New York, Texas, and Virginia. So, for example, Texas's laws cover medical fraud and fraud related to Medicare billing. And Virginia's is called the Virginia Fraud Against Taxpayers Act. And so Missouri also does have some anti-fraud laws, but again, those relate to healthcare. So 2 states to potentially be aware of in this space include Massachusetts and Colorado. And that's because the Massachusetts Attorney General has been particularly active in cybersecurity litigation. And the Massachusetts Attorney General does have a false claims division. And also Colorado is a state to watch, as the Colorado False Claims Act was signed into law in June 2022. And that did create a false claims recovery cash fund. So that requires that all proceeds obtained by the state from a Colorado False Claims Act case must be transferred to this fund. And then the Colorado Attorney General is statutorily entitled to keep a portion of those proceeds from those cases for use by the department. So that's particularly an area that could incentivize the Colorado Attorney General to pursue these types of cases. Similarly, there are also some cities and counties that have similar type laws. So, for example, Chicago has a city ordinance, as does New York City, and as does Philadelphia. And then Allegheny County, Pennsylvania also has a law. So while not every state is the same and not every state might have a law, those are areas to watch, and especially potentially Massachusetts and Colorado. And now I think I'll turn it back to Jim.
Thank you, Libby. So time for our second secret word polling question. The second secret word is defense. So please select defense from the list of choices on the screen for CLE compliance purposes. And so go ahead and do that. We'll give you a few seconds to do so, and then we'll move on with some ways to potentially mitigate some of these potentially enormous risks we've been talking about here. So please select defense from the list, and then we'll move on. All right, so let's move on to mitigating. So let's start with some steps to mitigate risks in this space.
So Jim, I'll take the lead on this, but invite my colleagues to step in at any point during the discussion. This is a very important topic, and I would recommend that anyone on the defense side or even the prosecution side, take a close look at these factors in deciding how to resolve a case, separate and apart from taking a look at these factors to focus on what can be done on the front end to avoid liability. But even if you're in the crosshairs of an investigation and it's ongoing, it's never too late to take a close look and see if you can avoid making a bad situation a worse situation by figuring out what can be done to avoid problems prospectively. So Jim, let's go to the first slide and talk about the first factor that we've identified. So are there strong internal controls in place? Having internal controls and policies to manage wrongdoing and internal disagreements related to cybersecurity, and ensuring that the approach to cybersecurity involves not only IT, but other functions such as compliance and legal. Next slide, Jim.
And let me jump in there real quick. Also, there's a lot of space for physical security for any organization to be involved in cybersecurity. And sometimes this can get overlooked, but there's been some push on the mitigation side in cybersecurity to focus on just basic controls and access to the space, and trying to not only through two-factor authentication keep people off networks that aren't supposed to be there, but also to keep people out of spaces that aren't authorized to be there. Go ahead.
That's a good point, Christine. And some of the points that we might consider in general, separate and apart from basic cybersecurity issues, are also relevant here, since so many of these cases come to the attention of the Department of Justice because of whistleblowers. Having a internal system, and strong compliance program, particularly for reporting incidents that should be reported. Christine discussed a number of these factors in her section on the regulatory issues. But you can see that from the settlement that I discussed earlier, failing to heed reports of these issues certainly makes a bad situation worse and heightens the exposure that a contractor, subcontractor, or grantee will face. So the second point here is their due diligence in connection with certifications to the government. So a company, a contractor or subcontractor grantee should ensure that any self-assessments or other certifications provided to the government are supported by reasonable inquiry and documentation, and that there is documentation in the file. Because a lot of this is really about being able to show that you're making a good faith effort, and taking these kinds of steps will go a long way if there is an issue, if there is an accident. Taking steps like this will go a long way towards helping to assure the government that you're in the realm of innocent error and a simple mistake, as opposed to a pattern or practice of misconduct. So, Jim or Christine, do you have any further comments on this factor?
Yeah, if I could point out one of the differences, I think, in applying FCA in the cyberspace from where it might apply in some other spaces is that the underlying subject matter that you're certifying to oftentimes isn't widely understood throughout the entire organization. Is when you're talking about information technology, information security controls, oftentimes it's a certain part of the enterprise that really understands the systems, really understands the controls that are in place. And so there can be communications issues. And so I think make sure that those who are reviewing this stuff really understand what you're certifying to. And so there may be some instruction, some education that's required up the organization to make sure that everybody who's involved in that chain understands what we're really certifying to here and what that means, particularly because some of these requirements aren't necessarily objective. Some of them are a little bit subjective. Those would be some of my thoughts there. Thanks.
Next slide, please.
I'd like to throw in.
Oh, go ahead. Go ahead, Christine. Sorry.
Excuse me. I'd like to throw in also that as in addition to what Jim and Claire said, I see this maybe not always in the cyber front, but possibly in the cyber front in the grantee space, because many government contractors have internal controls and processes in place for at least some of these cybersecurity controls and certifications, because this potential liability is so large for the FCA. But often with grants and research grants, it's easier for organizations to be a little bit less aware of what they may be certifying to, or what someone who works for them may be certifying to. There have been some recent False Claims Act prosecutions of grantees in universities for violations of various clauses in their grants, including export of information and things like that. Because I think in part, often what happens in a more decentralized organization, which grantees can be part of, there's fewer of these controls, and there may not be as much awareness about what is being certified to. And it can create a lot of liability, not just for the individual grantee or the lab, but for the larger research institution or whatever institution they're a part of.
Yeah, those are all good points, Christine. I saw a number of grant cases in my early years of handling the FCA cases, and I think some of the items that are prosecuted are not the type of things that grantees may even be ordinarily paying attention to. You know, switching gears on who's handling the major focus of the grant work or something like that. They just think they can, you know, bring in the next person, and, you know, that's potentially an issue. So there certainly should be a good compliance process and good controls in place there. So, you know, so tying to that here is also, is there a process to monitor guidance? A company, a grantee, a contractor will want to have monitoring processes in place to identify new guidance issued by government agencies related to cybersecurity. So Christine can probably tell you, since she's been monitoring this area for us, and Libby and Jim as well, that there are lots of new matters on the horizon. So what's done may be done for a day, but got to keep your eye on what's happening next, and make sure there's a system to keep an eye out for this new guidance that's going to continue to unroll. Jim, Libby, yeah. Christine, go ahead.
Yeah, absolutely. I think you've got to monitor the guidance and the standards themselves. You know, Christine talked about how CMMC is under revision, but you know, NIST periodically revises 800-171, and so you know, the underlying cybersecurity standards that you may be required to certify compliance with are constantly changing as the threats change and the nature of controls change. Those change as well, and I think sometimes people that don't have that technical background don't understand. I mean, the number of control requirements can be in the hundreds, or you know, potentially even thousands out there. So there's a lot of room for things to change over time. And so you know, monitoring the guidance from DOJ or other agencies, but then also the underlying cybersecurity requirements is very important here.
Next slide, please, Jim. So we talked about this a little bit, but again, just want to make sure that we emphasize this point that there needs to be adequate training. All of the things that we're talking about don't do much good if they're just sitting there on paper that nobody's paying attention to. We want to have a good system in place for training. So this is true of most compliance plans, but particularly with the complexities in the cyber area, it's very important. So a contractor needs to institute training for the company and personnel related to reporting and compliance with both the FCA and cybersecurity requirements. So also that should be tied to the detail of government contracts and grants. You know, with that particular focus, what are we required to do, and are our personnel understanding what it is that they're required to do and that we're certifying to? My colleagues,
right?
And
I think,
okay, go ahead.
Oh, let me jump in. I think this goes really well with what Jim just talked about the cyber regulations changing and guidance changing. Obviously, that means training needs to change, and the training isn't only for the compliance people. I think it's really important that, at least for a government contractor, that the training also go into the business development teams, the groups that are out there looking to try to get business for the contractor. It's important that they understand the certifications, that they understand that these are contracts they should be going after, and they can bid on. And it's also important in the grantee space because, for instance, at a university where you have grantees, training a bunch of professors on their legal requirements probably isn't anybody's first priority, but it's really important for the professors to understand how much liability there is out there, and that when they sign their grant application, just to make sure that they run things through legal if they have questions, and just to make sure they understand really what they're certifying to, because it's not just boilerplate language. It can really create problems for the institution.
Good point.
Yeah, and if I could add in, I think that oftentimes when we think about training, we're thinking about training down the chain. But a key component of a cybersecurity program, an increasing focus of regulators, AGs, and others, has been on the involvement of boards and senior management. And so with regard to FCA actions, the program for board or senior management involvement should be considered, making sure that those boards or senior management officials are appropriately informed and involved in material cybersecurity issues, making sure that they understand what the nature of these risks are and the controls that have been put in place for those. At least generally, they don't have to understand every technical aspect to it, but understanding generally so that they can make the necessary determinations that they need to for the organization.
That's true. A direct line of communication to the board is an important part of something that the government will look to as well. So all good points. So next point that we'd like to make here, or potentially a final point, is do we have adequate policies and procedures in place? So contractor, grantee, either of them need to perform regular reviews of cybersecurity related contract requirements and ensure that policies and procedures are in place to meet those requirements. One of the things that we emphasize when we're focusing on compliance plan is that we need to have a very particular focus on risk assessment and to continually have that review of risk assessment and to make sure that we have the right policies and procedures. So each of these points kind of roll together, but policies and procedures, as we've discussed, need to be updated as new regulations evolve over time. So having these policies and procedures ties together with the training and monitoring what's new and out there. So each of these points are significant and are tied together. So anybody, additional points on policies and procedures?
Yeah, one of the things I would point out is regulatory expectations around this. One of the things I've seen in the cyberspace is they expect you to review policies and procedures on cyber when there's been some material change to the organization. So you acquired a new company. And so then that changes the nature of the business. That necessarily changes the nature of the risks that you face and the controls that you put in place. So there's an expectation that you will review upon that. Or if you start offering new products or services, that changes the risk profile. And so you got to look at, do your policies and procedures reflect that changed risk profile?
I'll move on unless any of you have additional points to make. So this is really one of my favorite topics. It's a particular challenge. Having been on the prosecution side, I'm continually reminded of what advantages I had in working for the Department of Justice. These cases are filed under seal, oftentimes by individuals, who might have been working right next door to you, and there are a lot of interesting issues presented to us as defense lawyers. So, how would you approach the defense of an FCA cyber case such as those described above? Many of the points that I would think about here are relevant to other types of FCA cases I've defended over time, but sort of the initial point that I would think about is to conduct a very thorough internal investigation. And as part of that, as we've been talking about, I would also assess a company's compliance plan, both to see what might have gone wrong and how it happened and how we can tighten this up so that when conversations with DOJ begin, we can say, look, there was an issue here, but it was a mistake and we fixed it, and this is why it won't happen again. That's really important, to come with credibility and honesty as one begins a discussion with the DOJ. Next point is that because most of these cases are going to be initiated by whistleblowers and DOJ is going to be looking to see what's here, I would encourage defense attorneys to discourage DOJ involvement and action and encourage declination of the case from the earliest opportunity. Typically, there will be conversations that will begin with various witnesses. There will be subpoenas kicking out. So at that opportunity, asked to come in and talk to DOJ and emphasize the compliance efforts of the company and the resolution of any historical issues. Consider the feasibility of the return of funds, which does not involve an FCA settlement. That might be a little bit more complicated in this type of scenario, but it's something that I always think about in the healthcare setting. If there's a refund that's due to Medicare or another TRICARE, another government agency, get that money back in the hands of the government agency, whoever needs to get those funds. So there may be a way to translate that into the cyber area, and it's certainly something that I would think about here as well. Would look really carefully to make sure that there are express certifications of promised compliance, referencing the FCA and false statements in the contracts, and if not, point out the lack of those express certifications. Christine, I know that pretty much ties into the area you're very focused on. Do you have any additional comments on that area of the certifications?
Yeah, I think everything that Claire is talking about is would tie into how to get a declination, which is, in fighting these cases, the most important thing. Well, the most important early thing, at least, you can do, aside from hopefully not having this problem come up. You know, the getting the declination, I think there's a really large difference in the success rate of cases that DOJ prosecutes, DOJ intervenes in, versus those that DOJ declines to intervene in. And some non-intervened cases do wind up in a liability settlement, but and maybe even a win at trial for a relator. But the vast majority of cases where a company winds up liable for a big dollar amount is because is a case where DOJ has intervened. So I think focusing on, if you find out that there's been a problem with the organization, addressing it really quickly. If there's a cyber problem, if there's a hack, an incident, addressing it, investigating it thoroughly, and correcting the problem as quickly as possible will go a good ways to helping mitigate, like Claire said, trying to get into the honest mistake category. And I think maybe it's obvious, but one of the biggest ways to mitigate your FCA risks is to know your contracts really well. And aside from having the policies and procedures, know which contracts, if you're a company that has multiple government contracts or multiple grants, know where the cyber vulnerabilities are and which contracts have government information involved, and where you want to focus and prioritize your resources on compliance and making
so Christine,
sure that
those are good points. I think we're running close to like a minute or two away. So if you don't mind, I'm going to just jump in on the last 2 points here and then see if Jim has any wrap-up remarks. So excuse me for that. So I would also just add that one type of defense that I would offer here is to argue that the matter is at best a breach of contract action. That's something that sometimes deters the United States from thinking that it's truly a False Claims Act case. And also, again, as we keep saying, and as Christine was emphasizing, just to argue that there's only an innocent mistake, error, or negligence. And then finally, the final point that I just wanted to mention was that if there is a settlement, do your best to ensure that there's no parallel proceedings involving a criminal action or administrative sanctions such as debarment. Find out what you can find out as quickly as you can and ask those questions. and minimize dollars with creative theories. And that's a whole nother topic, how to calculate damages. We don't really have much time for that today, and look for the broadest possible release that you can get in terms of the coverage of the conduct and the type of release that you can get. So that's all I had. Christine, did you have something? I think we're about out of time. Did you have something you wanted to follow up on there?
I'm happy to let Jim talk.
Okay, thanks.
Oh, thank you. Yeah, I'll finish up with just a couple of very brief points on mitigating risk. Look, cybersecurity professionals are in very high demand. People in this space often move around more than most types of employees. Cyber also often involves outside contractors. So to me, this increases the risks of a whistleblower. So communications can greatly mitigate those risks. If it's not clear that something requiring attestation is being done or may not be met, decision makers need to be made aware and address that and talk to them. Another thing is segment your systems. Commingling data, if the CUI that's coming into the enterprise goes through a lot of different systems, then a lot of those systems are going to be subject to these requirements and then subject to attestations that need to be made. So to the extent that you can segment the systems, keep the regulated data more segregated, is generally going to be better, and that's going to lower your risk of liability. And so to close, I would note that the cybersecurity group is planning one more webinar this year in December. We're going to discuss preparation for the soon-to-be effective requirements of the California Privacy Rights Act, which is a law with impacts across the country and even outside the U.S. I want to thank you for participating in the webinar today. We hope you can submit the survey that's going to display at the conclusion of the webinar. And so from all of our panelists, I'd like to thank you for attending and hope to see you again for another webinar soon. Thank you.